everyone. So thanks again to everybody for joining us. I know from doing our client survey earlier this year, one of the topics of interest for a lot of folks was estate planning and what trusts are and wills and medical power of attorneys and all that good stuff. So I've been fortunate to know Molly McEvoy for close to 10 years now, and she's helped myself, helped my family, helped a lot of clients through the years. And she was generous enough with her time to speak with us today about the basics of estate planning. Today we do have the ability, if you do have a question, if you could put it into the Q&A section, we'll read the questions off as we get towards the end. And if there's specific questions to you, of course, feel free to email me or call me directly, and I can connect you with Molly, and we'll share all the information with you. But with that, I'm going to turn it over to Molly and let her go through our presentation, and look forward to any feedback you have.
Thanks, Matt, and thanks everyone for joining us. As Matt said, we do have the ability for chat questions. So if you think of a question while we're going through, please feel free to type it in so we can address it. I think sometimes it's a little bit more effective to address questions as we go. So please feel free to do that. The goal of today's program is to really cover the basics of estate planning. I want to give you just a little bit of background about what the federal tax system is, what probate is, the factors that we consider when we meet with clients, because our goal is to take the tax implications and the probate issues and work with our clients' goals so that we can most efficiently plan someone's estate tax-wise and administratively. So with that, we'll talk about the federal tax system. When we meet with clients, in the back of our minds, a lot of times people think with estate planning, we're only thinking about estate taxes. But that's really not the case. We're also thinking about income taxes, we're thinking about gift taxes, estate taxes, and generation skipping transfer taxes. I think income tax is pretty straightforward. We all know what an income tax is, and we all file our income tax returns April 15th of each year. A gift tax is imposed on transfers from one person to another. It's not always imposed. It's a lifetime transfer, and everyone has a gift tax exemption. Similarly, we all have an estate tax exemption. We'll talk in a little bit more detail in a minute about the gift tax and the estate tax exemptions. And then the generation skipping transfer tax is probably one that most people are not familiar with. And the generation skipping transfer tax is the tax that is imposed when a gift or devise in someone's estate is paid to essentially a grandchild or more remote descendant. I think that the code technically defines that person as someone who's 37 and a half years younger than the donor. But that Congress kind of wised up and realized that people were knowing that there's an estate tax, they were skipping children and leaving gifts further down. And Congress wanted to kind of capture that so that they weren't losing tax dollars. So with that, the gift tax law, the way the current gift tax law works is that it is imposed on lifetime transfers. And each person has a gift tax exemption of just under $13 million in 2023, which is a huge number. But that number is scheduled to sunset or be reduced to just right around half of that amount at the end of 2025. And that's based on current legislation. That is not based on what could possibly happen with the gift tax law in the next 2 years. Although given that next year is an election year, it's probably not likely that any of this is going to change in the next year or so. The current gift tax rate is 40%. So if you make a gift to someone that exceeds the $12.92 million, then you would pay tax at a 40% rate of the amount over that 12.92 million. So as I said, that's a pretty generous amount that can be transferred from one person to another without imposing a gift tax. In addition to that, there are other what we call carve-outs that don't go against that gift tax exemption. For example, each year you can make a gift of $17,000 to any person. You don't have to report it on the gift tax return. It's really pretty straightforward. You could write a check to everybody you know for $17,000 and you don't have to report it. And it's a really great way to do some gift tax planning, reduce your estate without having any sort of administrative, what I would call administrative expenses on that transfer. Another way that you can make transfers without using some of that gift tax exemption is paying educational expenses or medical expenses. The code specifically allows you to do that, and a great way to do it is just to pay tuition. I have a lot of clients whose grandparents or parents pay tuition for their children. As long as you pay it directly to the education institution, I believe it really has to be for tuition. I don't think it covers room and board. Although I think if the check is written directly to the university or to the school, I'm not sure that anybody's really going back on the details on that. But that's a really great way to one, help your family out. Again, deplete your estate responsibly and not have the administrative expenses of coming to a lawyer. And the same is true with medical expenses. I have another client who pays medical expenses for all of her children and grandchildren. And that's a pretty decent sum of money that she gets out of her estate. And again, it's no reporting. So those are a couple of ways that are really great to do that. And of course, spouses can make gifts between one another without having to report that. And you can make charitable gifts that don't go against that gift tax exemption. So there again, it's a generous gift tax exemption right now, but also with additional planning, you can use more than that 12.92 million if it's done properly. The estate tax is imposed on the value of property that's included in that an individual owns at his or her death. So anything that you own, does not matter how it passes, whether it passes by beneficiary designation or titling, you have to report those gifts if your estate is over the 12.92 million. You can see that the estate and the gift tax exemptions are tied together. They're both indexed for inflation. Again, the estate tax, along with the gift tax, is scheduled to sunset at the end of 2025. So beginning in January 2026, you will probably be looking at roughly $6.5 million per person of exemption. As with the gift tax, the tax rate is 40%. So if your estate is in excess of that 12.92 million, then you'll file an estate tax return, and then you may owe estate tax if the value of the net estate is over that $12.92 million. Does anyone have any questions on that? Matt, any questions?
We don't have any questions yet, but I'm sure
Okay.
we're thinking. But
Okay. So some things to think about. It used to be when I started practicing, the estate tax rate was 55% and the income tax rates were far, far lower. As the estate tax rate has come down to that 40%, and the income tax rate has gone up. The maximum income tax rate now, I think, is roughly 43.8%, and that's just the federal tax rate. When you factor in the income tax rate plus the Medicare surtax, you're at 43.8%. So when you look at an estate tax of 40% and an income tax of 43%, it used to be that the estate tax trumped and all planning was done to accommodate estate tax planning. Now we have to also consider income tax planning. One of the biggest benefits in income tax planning when someone passes away, I guess it's the silver lining, is that any assets that are includable in a decedent's estate get a step up in the income tax cost basis. So what that means is that if you owned a share of Coca-Cola stock that you bought for maybe $5 and you owned that share at your death, or let's say, so you owned the Coca-Cola stock valued at $5 and you give it to a child before you die, and it's worth $100. The child gets that, what's called a carryover basis. So they would get your $5 basis in that Coca-Cola stock. And if they turn around and sell it, then they have to pay capital gains tax on the difference between the $100 and the $5 if they sold that share of stock. You own that same share at your death, and it's worth $100 as of your date of death, then the new income tax cost basis is that $100. You get that step up in tax cost basis as of your date of death. So if your beneficiary inherits that same share as of your date of death and then turns around and sells it, there's no capital gains on that. So that's something that we try to consider, because we have a lot of clients with assets with very low cost basis. So while it's great to give those assets away, we have to think about what is the overall tax impact to a beneficiary and to the client. So sometimes we try to keep those assets with low cost basis in an estate, because they do get that step up in income tax cost basis when someone dies. Again, we also have to look at what the capital gains tax rates are. Right now, they're still pretty favorable, but I know that that's been kind of questionable as to how long that's going to last. So that's something to think about. Another thing to think about is grantor trust planning, where the grantor trust, the person who creates the trust is the person who's called the grantor. And with grantor trust planning, you can create certain types of trusts where you actually give the assets away, but if the trust sells those assets, any items of income, so that would be interest, dividends, or any capital gains in the trust, the person who created the trust pays that tax. Again, that's a huge benefit, because paying the tax doesn't require the trust to deplete its own assets if the trust sells an asset. So that's another great way to plan, again, effective use of the estate tax exemption and tax planning. Now, of course, if you're going to go down that road as the grantor, as the person who creates the trust, you have to make sure that you can absorb that income tax expense outside of the trust, because sometimes a lot of times people do that with items where they'll have a big capital gain. And it's great for the trust, but the grantor has to be able to absorb that tax consequence. So that's definitely something to think about when considering how you're planning. So as I said, the tax is the one side of the equation that we as estate planners think about, because that's something that most of our clients don't really know about. Then the other side is the probate. And a lot of people I hear a lot of clients come in and say, I just want to avoid probate. And so a lot of times they don't know what that exactly means. And the process of probate can be quite simple. Essentially, it is presenting a will or a writing in the court where the decedent died for admission as the decedent's last will and testament. And notice I say a document, because not always is it a clear last will and testament. And the law, Virginia law has changed a little bit over the last couple of years to be a little bit more flexible in terms of what is admissible as a will. But so the probate process is actually admitting that document to the court. And then the clerk's office looks at that document and determines if it's acceptable, because there are certain requirements in the Virginia statute that a document must meet to be acceptable as a will. It's got to be obviously signed, it has to be witnessed, it has to have certain formalities. And if it is accepted for probate, it's recorded in the clerk's office, and then it becomes part of the public record and is then on record as the decedent's last will and testament. What goes along with probate is when the more complicated piece to probate is when you have an executor or administrator qualify as being in charge of the estate. And the executor or administrator has additional reporting requirements to a commissioner of accounts. And the commissioner of accounts serves as an officer of the court. And their job is essentially to make sure that the fiduciary, that executor or administrator, is doing what he or she is supposed to do and in accordance with the writing that was admitted as the will. So essentially when people say they want to avoid probate, I think really what they mean is they don't want to have to go through those extra hoops of reporting to a commissioner of accounts. Because the commissioner of accounts wants to make sure that if a bill is paid from an estate, that it really was the decedent's bill or is related to the estate. So their job is to go back and double check everything that an executor does. So a lot of times it requires documentation, very detailed documentation. A lot of times people don't want to have to go through that. So we often help clients determine ways that they can avoid probate. Another reason why people don't like to avoid probate is when you have those additional documentation requirements and reporting requirements, that's an additional cost. You also have to pay a probate tax on assets that go through probate. So there is a cost associated with probate, a financial element that people really don't want to incur if it's not necessary. So certain ways around that are how assets are titled. Let me back up a little bit. Anything that goes through probate is something that's owned in the decedent's sole name. So anything that is jointly titled, for example, on the slide, you see account titling. If you own something jointly with right of survivorship, or you have accounts with Matt that are transfer on death, those don't go through probate. The beneficiary designation or the titling of that account controls how that asset passes. Beneficiary designations are also another way to avoid probate with particularly retirement accounts, life insurance. You've probably all already done some estate planning by filling out retirement account paperwork or life insurance paperwork and naming a beneficiary. Those assets also don't go through probate. Now, if you haven't named a beneficiary or you don't have any kind of specific account titling, then those assets pay to your estate and would go through probate. Where we come in addition to helping make sure that the account titling and the beneficiary designations are consistent with an estate plan, is preparing a revocable trust for people. And the way that helps is you can have a revocable trust, but if we don't either title our accounts appropriately or name the appropriate beneficiaries, then we're not avoiding probate. So the goal is if you set up a revocable trust that you fund that trust, meaning you could have a brokerage account in your sole name. And when I say fund a revocable trust, I mean that we would retitle the name of that account into the name of your revocable trust. And then at your death, it doesn't go through probate, it stays in the trust. Now, there are some administrative details that you have to take care of with the trust, but typically it's much faster and more efficient to handle that through a revocable trust. Oh, Matt, somebody just asked if this is being recorded. Yes, it is being recorded. So going back to the revocable trusts are a great way to avoid probate and the complication. Again, when we meet with clients, sometimes we're trying to figure out if a will is sufficient or if they would prefer a will and a revocable trust. Sometimes people have a fairly straightforward estate and really may not need a will and a revocable trust. But on the next slide, I sort of explain like a will, when you probate the will, it becomes a public document, it becomes part of the public record, and there is some ongoing reporting to a commissioner of accounts. The revocable trust affords privacy because a revocable trust is not probated, so it does not become part of the public record. You can change a revocable trust at any point in time. If you are not able to manage your own assets during your lifetime, a successor trustee can serve in your place. Typically, my clients are their own trustee with a spouse, a successor trustee, and that facilitates easier management of assets during lifetime. And as I said, the assets become available more quickly at death. Sometimes, and depending on the jurisdiction, it may take a couple of weeks to a month to get a probate appointment. And what that means is when someone dies, their accounts once you notify a financial institution that someone has died, their assets become locked up. The financial institutions place a hold on the account. And if the account is in an individual's sole name, until an executor comes to collect those assets, the financial institution will not release those funds. Again, going back to ways around that, you could have someone on that account for convenience, or you could title it in the name of your revocable trust. Now, if you have it titled in the revocable trust, you still need to notify the institution that someone has died, but the trust becomes irrevocable, but the paperwork and that process of accessing those funds again is much quicker, because you've already got a successor trustee named in the document. The successor trustee just has to accept those duties, provide certain information to the financial institution, and you're up and running. And it's usually within a week or so, as compared to that month or possibly longer period of time. As I said, it depends on an individual circumstances. I have a couple clients right now who leaving everything outright to spouse. They have adult children and just want to leave everything to the kids. And in those cases, if you name the fiduciary as surviving spouse and they leave everything to surviving spouse, we can eliminate a lot of those ongoing reporting requirements to a commissioner of accounts. So sometimes that works and it's easy. Almost always we have what's called a pour-over will to a revocable trust. So even if I have a client who comes in and says, I just want to do everything in a trust, and they retitle almost everything into the name of the revocable trust, we still prepare what's called a pour-over will. And it says, I leave everything to my revocable trust. And the reason for that is that sometimes you miss assets. Sometimes, quite honestly, like there's something out there where people just forgot about it. A lot of times I see this with clients who have shares of stock that are still in certificate form, and maybe they're in a bank safe deposit box and they get their dividend checks from Computershare, but they still have their certificates. And so that's where it's really important to have a vehicle to get those assets to that revocable trust. Because if you didn't have a will, and you essentially died intestate, even though you had a revocable trust, those assets may go a different place than where you want them to go. And not only that, but they may pass in a different manner than what you want them to do. So typically clients, even though we're doing trust planning, they have a will and a revocable trust, just to make sure that we've got that safety net to catch all of those assets. When we have a revocable trust, what we try to do is give clients information as to how to retitle assets during their lifetime, so that if it's Molly McEvoy's sole name, I want to transfer it to the Molly D. McEvoy revocable trust under agreement dated and whatever the date of my trust is. And a lot of times I think that's easier because you can use those as if my successor trustee would need to act, those assets are already in the trust. And I think that's my number one choice. That would be my best alternative for clients, is to retitle assets into the trust during their lifetimes. Another alternative is to name the trust as a beneficiary at a person's death. While that is sort of a good second option, sometimes that can also delay the accounts getting open and the assets being available, because there's really nothing in the trust currently. It just takes a little while. Anytime you're trying to collect assets at an individual's death, it's you've got to fill out paperwork and provide death certificates, and sometimes it takes several days to get a death certificate. It's just a lot of back and forth. So again, that's why I prefer to retitle them during lifetime if you can. But second best would be to name the trust as a beneficiary. And oftentimes that revocable trust may have ongoing trusts for spouse and or children. So I just like to get everything there sooner, because the sooner we can get that administrative trust going, the sooner we can get the assets funded. And why that matters is so that your beneficiaries have access to funds sooner rather than later. Because if you haven't gotten it funded, I'm working with one right now where the trust beneficiaries have been told it will take 12 to 24 months to get those residuary trusts funded. So again, I think it would have been a little bit better if the assets had been titled in the trust during their lifetime. All right, I'm going to check the questions again.
Yeah, just to jump in, we had somebody write in a question that was saying that there was a suggestion that a will and trust is not sufficient enough, that we should have a specific Medicaid will and trust to protect assets. And what does that mean, and how does that apply to folks?
Okay, so a Medicaid trust, that is a little bit different planning, and it's definitely outside the scope of this presentation and outside the scope of my wheelhouse. What I know enough to be dangerous in the sense that if you are trying to do Medicaid planning, Medicaid requires that you, to be qualified for Medicaid, you've got to spend down your assets. And there is, I think, a 5-year look back. So if you make gifts of your assets and then you need Medicaid within 5 years of that gift, you become ineligible. And so then you're not eligible for Medicaid and you've made a gift of your assets. So you really have no resources. It sounds like what that financial advisor might be talking about is setting up a trust that's a little bit tighter than what I'm calling a revocable trust to do that Medicaid planning. But again, that requires very specific knowledge of your circumstances and specific, more detailed knowledge of the Medicaid laws, which is again not something that I typically deal with, just because the penalties for making a mistake, whether it's inadvertent or not, are pretty strict. So you may want to go back to your financial advisor and ask about that. And if you did need to go to somebody who does that type of planning, I'm happy to give you some names of people who specialize in that. As a part of our planning, we've talked a lot about the will and the revocable trust. There are other documents. The first two here, an advanced medical directive and a durable power of attorney, I think are as important as an estate plan, because they function while you're living. And I think between the 4 documents, will, revocable trust, advanced medical directive, and durable power of attorney, you're kind of getting a complete package so that somebody can help you if you need it, whether you're living or deceased. The advanced medical directive names an agent to make healthcare decisions only if you are not able. If you have capacity and can make your own medical decisions, the physicians will listen only to you. They will not go to an agent. If you are incapacitated, the advanced medical directive names an agent to act on your behalf, and it also outlines it outlines your wishes regarding your care, both during your lifetime and end of life. It's serves as a living will. So if you don't want to be kept alive on life support, then the document would outline that. Sometimes clients have really specific wishes regarding being kept on life support, or pull the plug, or keep me on life support for 30 days or 24 hours. Sometimes clients have very specific parameters on that. Our advanced medical directive also serves as a document for organ donation. So if you want to be an organ donor or do not want to be an organ donor, we outline that there as well. A durable power of attorney is a financial document. It allows someone to make financial decisions on your behalf. It is durable, so that means that you don't have to be incapacitated for somebody to act on that. It just allows somebody, if necessary, to fund your revocable trust, or to pay bills if you're not available. It's a very broad power, but again, between those 4 documents, I think you're kind of getting a whole picture for what someone might need during lifetime. The trust certification is documented. If we set up a revocable trust, a lot of times when we're changing beneficiary designations or retitling assets, a lot of times financial advisors or banks or financial institutions want to see a copy of the whole document. And under Virginia law, you were allowed to provide a trust certification that contains all of the important details that a financial institution would need: the name of the trust, the grantor, tax ID number of the trust, which is the grantor's social security number, that the trust is in existence, several other things. That trust certification sort of serves in place of giving somebody a copy of the whole trust. So that's actually really great for people who are trying to do trust planning for privacy purposes. That's a really good way to kind of close the loop on that. And then we also provide suggested beneficiary designations for our clients so that they know, we've created these great documents and we've looked at all of their assets, but if we don't kind of close the loop and either retitle the assets or provide beneficiaries for those assets, then the assets may not pass the way the client expects as we meet. So we also do provide beneficiary designations for that. I'm going to check. There's another question here.
Yeah.
Planning to get remarried midlife, is it possible to set up individual trusts that will protect each person's assets in the event the future spouse gets sick? We both lost spouses young. Let's see. Again, this is an asset protection question. You can leave assets in trust for surviving spouse. But again, I'm not sure if you're talking about during lifetime or at death, but if you leave assets in trust for surviving spouse, then the trustee gets to control what those distributions are. That would probably protect your assets a little bit, depending on the terms for distribution.
And Molly, wouldn't the trust also help to protect the assets for the children too, the surviving kid?
It would, yeah. In the case of a second marriage, that's also a trust for surviving spouses is generally a good way to protect assets for your respective children. So you would each have a trust for each other, and then for your respective children.
Good question, and I think it kind of solidifies how important this is to plan for, because there's so many different scenarios that can happen, and Molly and her team really dive into your specific scenario to say, here's what you want to do, and here's what somebody else might want to do, and they can. The cool thing about attorneys, they can specialize it and make it specific to you and your scenario for sure.
Okay, so we're going to jump topics here to the Secure Act and the Secure 2.0. This first slide is really what came out in the original Secure Act, which is retirement asset planning. And I thought this was relevant because although Secure Act is a couple of years old now, Secure 2.0 came into effect last year, but the changes to payouts are fairly substantially different than what we all had become accustomed to, which was that you could roll retirement accounts to surviving spouse, and then you could divide it, and the kids could inherit those retirement accounts and take out payouts over their lifetimes. And that was a great planning vehicle. But about 2 or 3 years ago, Congress said, no, enough of that. And without diving too far into the weeds, the general rule is that a child can take a 10-year payout. Sometimes you're restricted to a 5-year payout, depending on certain things. But essentially, whereas we used to get that lifetime payout, where, again, as I said in the beginning, we also consider income taxes. That was great, taking smaller distributions out over a life expectancy of a younger person. You're paying the income tax at a much slower rate. And I think Congress finally realized that was kind of a boon to generate revenue, and said, okay, we're going to stop that lifetime payout, and we're going to stick with a 10-year payout. So by the end of the 10th year, the entire retirement plan has to be withdrawn. The exceptions to those rules, there are 5 exceptions to those. The surviving spouse, essentially with Secure Act, surviving spouse rules were essentially unchanged. Meaning that surviving spouse can inherit. They can also choose to roll it into their own names and take it out over life expectancy. Of course, all of this is subject to whether the decedent had started taking distributions or hadn't started taking distributions. That all factors in. But essentially, for the surviving spouse, it's a fairly similar situation. If your beneficiary is a disabled individual, they are also not subject to that 10-year payout. Same is true of chronically ill individuals, minor children of the account owner, and an individual beneficiary who isn't more than 10 years younger than the account owner. So again, trying to be reasonable. Obviously, you're not going to make minor children take out those retirement assets, but once they hit the age of majority, which I believe for purposes of this is age 18, then they do have to take it out over 10 years. So there are a few caveats in here. But generally, we've gone from a life expectancy to a 10-year payout. Some other changes that came through in Secure 2.0 was that it raised the required beginning date to take required minimum distributions. It used to be that if an individual turned 70 and a half, they had to take distributions beginning the year following that. That age under the Secure Act became 72. And then effective with Secure 2.0, it's 73. And I believe that within the next 10 years, that age is going to go up to 75. So you can be as old as 75 without being required to take distributions from your retirement plans. Additionally, once you reach age 50, you can do what are called catch-up contributions, and you can contribute more money to your retirement savings. The Secure 2.0 added several additional catch-up provisions. Trigger ages are 50, 60, and 70. Another big benefit to Secure 2.0 is that they have changed some of the penalties. It used to be that if you did not take your required minimum distribution, there was I think it was a 50% penalty of the amount of the distribution. And it was subject to self-reporting, but it was a pretty big penalty. Now, the IRS used to waive that penalty regularly. So if you missed a distribution, and it's kind of confusing, especially with that first year or so, the IRS would waive that penalty if you requested a waiver and abatement of the penalties. Now that they've reduced the penalty, I think that the thought is that the IRS may be less likely to waive that penalty. But again, the penalty is not 50% of the missed payment. And then there are additional exceptions for so that you're not subject to early withdrawal penalties for hardship and other circumstances. So I think given the economic climate and what everybody's been through with the pandemic, it seems like they're trying to get a little bit softer on some of those penalties to allow people a little bit more flexibility. And I think just as a public policy, the reason why some of these changes to Secure and to retirement planning was done was to incentivize people to contribute more to their retirement plans, and really incentivize people to save, so that it's better for everybody if there's savings, and then you can take it out over time. I think that might be one other
question here. Yeah, does the 10-year payout apply to inheritance of a Roth IRA?
It doesn't. The Roths are not subject to required distribution, so that I do not think that the 10-year payout applies to Roth IRAs, because the tax has already been paid on the Roth. So again, that's a really quick overview of Secure and Secure 2.0. To go into the detail, we could spend hours, and you guys would all be asleep, especially if you haven't had lunch. Does anybody have any other questions? Matt, do you have any questions?
Yeah, there's another question that popped in. It was the importance of, in general, the importance of doing this type of planning, whether somebody is married or single or has kids. And I think it was in just of getting the basics of a will, trust, power of attorney set up. And does it matter if somebody's single or married or with children?
Well, of course, the answer is a typical lawyer answer is that it depends. I think that if you're married and the kids are from the same marriage and you don't have an estate plan, things will generally work. Meaning that under the statute, surviving spouse would inherit everything, assuming that that's what you want. So I think that's probably the easiest. If you are a blended family, then surviving spouse gets a third of under the statute. So if you have no planning, surviving spouse would get a third, and your children would get 2/3. But again, you have to remember that any beneficiary designations and things like that control. So you may have had to name spouse as 100% beneficiary of retirement plans. So you've got to go check on all of that. Even if you don't have an estate plan, you've got to make sure that those beneficiary designations are what you want. Because if you don't name your spouse as 100% beneficiary, I think you have to have their consent. So again, it's a conversation that you have to have. And I think it's funny, I have a lot of single clients who come in and think, oh my gosh, this is really easy. I'm not married. I don't have any kids. And then the question begs, well, what do you want to happen to your assets? And so I think it gets a little bit more complicated than they sometimes think, because it's, this is really easy. I don't have anybody that this has to go to, but then it becomes the question, okay, where do you want it to go? So sometimes it's a little bit easier when you have the default as to where you want those assets to go. So I think regardless, it's really important to think about, even if it's just a simple will, just so that you have a little bit of control over your own destiny. Otherwise, you're defaulting to the statute and kind of at the mercy of the statute or your beneficiary designation.
Another question that popped in was how often, like, so once you have your documents enforced and you've met with yourself or another attorney, how often should you review your trust or will or power of attorneys that you have set up?
That's a great question. I typically say every 3 to 5 years, because I think, things happen, life happens in 3 to 5 years. And it may be that you revisit it and there are no changes. Maybe that maybe a fiduciary has moved away, or maybe somebody that you thought was who was a close friend when you created the documents maybe is not still close. So I think, 3 to 5 years, or if a major life event happens, you get married, you get divorced, you have another child, a parent passes away, any of those things are good times to take another look. Let's see, when including wish or desire regarding who would raise the child in the event of simultaneous death. Yes, so you do, both spouses would have a guardian provision in their wills, and it would be the same person. You bring up a good point. It is only a nomination, but I've never seen it where someone nominated in a will was not named the guardian by the Commonwealth. So yes, the Commonwealth typically honors that, but the guardian has to go to court and qualify, and has is basically under the subject to the purview of the courts as the guardian of a minor child. Let's see. So you can choose that. Well, yes, you can have a will. You can do everything in a will that we could do in a will and a revocable trust. But if you have a revocable trust, you will also have a will. So I don't know if that makes sense. I have some clients who just have wills, and that's fine and it works. And then if I have a client who has a revocable trust, their will leaves everything to the revocable trust. So if you have a revocable trust, you have both. If that makes sense.
It does, yeah.
Okay. All right, any other questions?
No? Okay, well, this was great. Once again, thank you for the information and education that you've provided all of us. And obviously, if there are further questions, feel free to reach out to me and I'll connect you with Molly. And I think it shows us that there's so many different scenarios out there and everyone's situation is different. It's certainly important to get all the documents in line. Make sure your beneficiaries are who you want them to be. And then obviously make sure you have all your legal documents enforced just in case something happens. There's so many unknowns and what ifs and things that can happen to all of us. And it's important to have these documents laid out so that your intentions are taken care of. So I want to thank Molly once again, and I appreciate all the time and education you've given us.
Well, thank you very much, Matt. And if anyone has any questions, my contact information is at the beginning of the presentation.
Yeah, and we'll share that with everybody again.
Awesome. All right. Well, thanks, Matt.
Thank you. Have a good day, everyone.
Okay.
Bye-bye.
Take care.
Thanks.